Hi, I'm your Orange County Clerk of Courts, Tiffany Moore Russell. I have a very important change to share in the filing of civil court documents concerning confidential information. Due to a Florida Supreme Court amendment to the Rules of Judicial Administration 2.420, the responsibility will now rest on you, the filer, to protect your personal information when filing civil court documents. Whether you are an attorney or choose to represent yourself, the filer now needs to notify my office of confidential information that needs to be redacted in any civil and small claims court records filed with my office. Here are more details on the procedure so you will know before you file.
Attention attorneys, legal professionals, self-represented litigants, and anyone filing court documents in Florida. Based on a recent Florida Supreme Court amendment to Rule 2.420, there are changes that you need to know about when filing documents with confidential information. The changes affect most civil cases, including small claims cases for legal disputes $8,000 or less, county court civil cases for legal disputes between $8,001 and $30,000, and most circuit court civil cases above $30,000 and appeals from county court. They do not apply to criminal, domestic relations, probate, or special case types. Here's what you need to know. Rule 2.420 already requires filers to protect confidential information in the documents they file. But now, clerks of court are no longer required to review and remove confidential information in small claims court filings, county court civil cases, and most circuit cases unless notified by the filer. That means that in these cases, filers are now solely responsible for identifying confidential information contained in these court records to ensure it is appropriately redacted. Starting July 1, 2021, it's critical that you properly identify this information to prevent it from becoming publicly accessible. Here's how. If the filer who is drafting a document believes it contains confidential information, they should first exclude it if it isn't necessary information. Or second, complete a Notice of Confidential Information within Court Filing form before filing. To access this form, you can contact your local clerk of court or visit their website. These forms are available in every county, and they collect the same information. Filers are required to identify the precise location of all instances of confidential information within the document, including page numbers and attachments, appendices, and exhibits. On many forms, you are required to select whether the entire document is confidential or to identify each instance of confidential information. Filers are also required to identify the type of confidential information that applies. According to the rule, there are 23 types of confidential information that can be redacted, including social security numbers, bank accounts, victim identifying information, and more. If a notice is filed but the information is not considered confidential, the clerk will notify the filer within 5 business days, locking the document as confidential for up to 10 business days to allow the filer to file a motion to determine confidentiality of court records. If no motion is filed after 10 days, the information may become public. Once the motion is filed, the clerk will keep the document in a locked status unavailable for public viewing until the court rules on the motion. Please take the time to carefully review and understand these changes. It's up to filers to identify this confidential information and protect it from becoming publicly accessible. And it's up to attorneys when filing on behalf of a client. For attorneys, failure to identify the information properly could result in sanctions or bar disciplinary action. If you have any questions, please contact your local clerk of court.